Hi, everyone. My name is Rachel Marks, and I'm the Director of Education here at SunRay. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. SunRay secures over $10 billion annually. Today's webinar is conducted by the incredible Leslie Bowe, a Missouri and Kansas construction lien law guru. Today's webinar topic is, what happens after I record my lien? How do I get paid? So without further ado, I'd like to introduce the fabulous Leslie Bowe.
Good morning. Thanks so much for the opportunity to be here. I'm happy to talk about this topic. It is a very commonly raised question with my clients is, now what do we do? How are we going to get paid? So I'm pleased to be here today. As we get started, I just want to note that if you have any questions, we will take those up at the end. So you should have a chat box on the right where you can post your question. Don't hesitate, ask as many questions as you like. There are no dumb questions. Happy to respond to them all. If you don't get to it, my contact information will be attached at the end of the webinar, so you can always reach out at a later time. So with that, let's just get started. If you're listening to this, you probably have already heard, or maybe you're very well aware, that your mechanic's lien is a very powerful tool to get you paid. And this applies to your bond claim as well if you do not have lien rights on your project. Just real briefly, one of the reasons it is a very powerful tool to get paid is because it's involving other parties besides the entity that's not paying you. We've got pressure on the owner because now we're encumbering their property. The fact that there's a lien on the property may be upsetting the bank. If this is tenant finish type work, the landlord's not going to be happy with the tenant. And everybody knows that the end result, if we go all the way to the end of the game here, is the property can be sold to satisfy the lien. So there's times where this is the only way my clients get paid. If whoever was supposed to be paying you is out of business, in bankruptcy, whatever the situation may be, this is oftentimes the only way we see our clients get paid is with a good lien or bond claim. So enforcing a mechanic's lien, there's sort of three phases to the life of a mechanic's lien: attachment, perfection, and enforcement. So one of the great things about a mechanic's lien, and in Missouri, this is true, and it's true in a lot of states, is that your lien will actually attach from the first day of work. So this is how we oftentimes get priority amongst other, maybe there's lenders with encumbrances on the property, but because a mechanic's lien will attach from the first day of work, we call it the first spade rule in Missouri. This will oftentimes give you sort of a super lien or superpower in terms of your negotiating position and your right to enforce your lien. Perfection process in Missouri is the filing of the lien. So in some states, actually filing your suit is a part of the perfection process. This really only comes in, the distinction is really only important when you have situations where you're trying to enforce a lien and maybe one of the interested parties is in bankruptcy and you're trying to figure out if you can go ahead and file suit or not, given the bankruptcy stay. So, but here in Missouri, you can go ahead and file your lien without any fear of upsetting the bankruptcy court. And then the enforcement, which is what we're here to talk about today. So enforcement starts with filing a lawsuit to enforce and foreclose on your lien. It goes all the way through to the end, which would be a foreclosure sale. In order to talk about this phase, we are going to assume that your lien has already been perfected. So that means of many, many issues, the key ones would be that you are a proper lien claimant. Your lien claim is for lienable items. All the notices that may be required have been properly given. Either the method of service was properly followed, whether personal service is required or mailing, and that all notices were timely given. So just for example, in Missouri, where we're talking about today, a subcontractor who's going to file a lien has to have given the owner of the property 10 days notice first, and that has to be personally served. So there's one of the reasons you don't want to wait to the very last minute is sometimes we have trouble tracking down an owner and getting service. So all of your lien rights and bond rights are very time sensitive. So it's important to be aware of those time limits and make sure that you, when it comes time to file suit to enforce your lien, you've done everything that you need to do to have a good lien. So notices also the lien was properly filed. The contents, it contains everything that's required. It was filed timely and that sort of thing. So if you've got all those things in place, then we can start the enforcement process, which begins by filing a lawsuit to enforce and foreclose on your lien. It will need to be filed within, in Missouri, we file within 6 months of the lien being filed. And we don't test these limits nowadays with electronic filing. There are ways to obviously file a lawsuit over the weekend and whatnot, but we always are very aware of that deadline. We don't want to push it because unlike other deadlines that commonly occur with filing things in courts, you wouldn't get the benefit necessarily of like filing on the next business day or there was a holiday so the courthouse was closed. So we want to file within 6 months so you don't get the extra day if your 6-month deadline falls on a Sunday or something like that. This is more for your lawyer to worry about, but your proceedings are going to be the same as in any other regular lawsuit, but in a lien enforcement action, you obviously have to allege the facts necessary to secure a lien. And we also have, the statute requires that you include a description of the property charged with the lien. So if you have filed a lien with just the information you had on hand and without getting a report from a title company or doing any research into the property information as far as like the legal description and that kind of thing, this is something that you will have to do before filing suit. That also plays into the next issue, which is who do you name in the lawsuit? You need to name every party who has an interest in that real property, because if they're not named in the lawsuit, they're not going to be bound to your lien. So if there's a lender with a mortgage on the property, you need to name that lender as a party to the lawsuit. Otherwise, they aren't bound to any court's decision about your lien. Also, one question that comes up fairly frequently is whether we have to include the entity that didn't pay you. So if you're owed money by a subcontractor or a general contractor and they're gone, they're in the wind, nobody knows where they are, you do still have to name them because you do have to establish the breach of the contract that led to your being owed money. So in order to have a successful lien claim, you also need to have a successful claim, a successful count against that entity that owes you the money, whether it's a breach of contract, action on account, or even an equitable claim because you don't have a written contract. Just a little bit of a note here, because this question does come up. Many states have statutes that allow for a lien to be bonded around. This is used by owners when they don't want the lien sitting on their property because they may need to sell the property, or in tenant finish type leasehold in situations, the landlord doesn't want a lien sitting on their property. So just for example, on the other side of my state line of practice in Kansas, we can bond around those liens by statute without anybody's permission. Missouri doesn't have that, but we are seeing more and more often the parties agreeing to a bond. So if somebody approaches you to say, hey, we don't want to have to deal with your mechanic's lien, but we're willing to post a bond, you'd want to have some conversations with your lawyer about why is it they're proposing this. You know, I've had situations where we didn't agree to the bond and ended up getting paid quicker because there was obviously some urgency to not have the property encumbered. If there are concerns about the value of the property or you know, whether or not you're going to have priority of your lien, you may like to have a bond in place because then you know the money's there. You prove up that you had a good lien and you have a good place to go get paid from. You know, the surety would then pay the successful lien claimant. So that is, it doesn't happen as often in Missouri because, like I said, we don't have a statute for bonding around liens, but we are seeing it come up more and more often, mostly on commercial projects, obviously. And then assignment of lien claims. So occasionally, if you're a subcontractor working for a general and something's happened, there's a big dispute with the owner, and that's the reason you're not getting paid. We've had several situations where the general contractor will take an assignment of the lien claim, and the terms of that agreement can vary widely. Maybe they just pay you and take assignment and go pursue it with the owner. Maybe you're trying to think outside the box and get something resolved, so you may agree to a partial payment with an agreement that you would get paid in full, when the contractor's done pursuing the claim against the owner. But that is an option sometimes, to get a client paid promptly. As far as the enforcement action goes, it's litigation, so it can take time. And on lien claims on projects where there are a lot of lien claimants, it can unfortunately be a cumbersome process. However, at the end of the day, when you prove up that your lien was proper, you properly perfected it. In other words, you filed all the notices right, you filed the lien properly. You'll get the end result is you get a court order saying, yes, you have a lien, it's properly perfected. You've got a valid legal interest in the real property, and the court will order that the property may be sold to satisfy the lien. So I will jump in here and say, it is not often that we get this far in the process, right? Because the lien is such a powerful tool, like we talked about in the beginning, to get paid. A large majority of our lien claimant clients get paid before we ever get to this step, before we ever file a lawsuit. I believe everybody lives on one end of a spectrum. Some people pay their bills when they get the bill in the mail. Some people, it takes maybe a letter from a lawyer. Some people, it takes getting sued, which then forces them to hire a lawyer and file answers and start spending money. But again, there are situations where you're not going to get paid until the very end of the game, once you've got the judgment. And I mean, I've even had people get paid after the judgment's obtained, after we've scheduled this, the sheriff has scheduled the sale for the property. And that's what finally got them to come up and make payment. That's assuming there's somebody who cares enough not to have their property sold on the courthouse steps to satisfy the lien. So keep in mind that while we are talking about enforcement and what it takes to go the mile, go all the way to the end of the race, it is very rare that we ever get to this point. Some people pay as soon as the lien's filed. Some people will get motivated once they see how long the litigation could be drawn out and how much money that would cost, and therefore that might get them talking about payment. If we do get to the end of the road, unfortunately, this does happen when there is nobody to pay, and everybody's maybe there's parties in bankruptcy or whatnot. The enforcement is the sheriff will sell the property, and then this is a procedural thing. There'll be paperwork that needs to be filed, but it's called a writ of execution. The sheriff attaches the property and sells it at an auction type sale. One thing to note is that if the proceeds are not sufficient to pay all of the lien claimants or other people with an interest in the property, then the proceeds will be split pro rata amongst all the lien claimants. So in our state, unlike some other states, there's no need to race to the courthouse to be the first one to file the lawsuit, because all the lien claimants are going to be considered by the court to be in the same creditor slot, so to speak, and the payments will be split pro rata. We've got a few minutes left, and I don't know if we have any questions rolling in, but just briefly, I threw this in here because these are the things that can cause lien litigation to become more protracted. If you don't have a great lien on file, then there's something for the defendants to pick at, and you're going to end up fighting this out in litigation as to whether you actually do have a good lien. Did you include the just and true account that we're required to do in Missouri, that puts the owner on notice of what is included in the lien claim? So in Missouri, we have to itemize the labor and materials so that somebody could look at the lien and investigate the propriety of the claim. Priority issues: there may be a superior lien on the property, And then that would be a situation where you may want to be looking at, be open to maybe a bond if someone's suggesting that, because then you've got to figure out if the property's worth enough and is going to sell for enough to satisfy the various lien claimants. Another issue that comes up in litigation as a defense to a lien claim is lien waivers. So we actually will have a seminar similar to this, a webinar, a little bit later in the year about lien waivers. We want people to be very careful about what they're signing, because you can waive some of your lien rights if you don't read those carefully. They're typically limited by either time or amount. So we want those to be read carefully. And if you need to preserve any claims, say there's a disputed payout out there, or a change order that hasn't been agreed to yet, before you sign a lien waiver to get your progress payment, you may need to handwrite in there that we are not waiving any lien rights with regard to the disputed change order number 2, or whatever the case may be. And then public property. So some people, public payment bond claims also have time limits built in, and you need to be aware of that when you start this whole process, because you'd hate to go down the road filing a lien and then find out that your lien's getting kicked out of court because this wasn't even lienable property. And if you've gone that far down the road, then you might have lost out on the opportunity to make a bond claim. So these are all things that you have to be aware of all through the process of pursuing your claim, to make sure that at the end of the day, once you're standing in front of a judge to prove up the validity of your claim, you don't have any lien killers out there waiting to cause you problems. At this time, I'm wondering if we have any questions. Rachel?
Okay, let's see here. I don't see any questions that have come through. However, if anyone here does think of a question after the webinar, please feel free to reach out to myself or Leslie, and we will make sure to answer any questions you may have. If you'll just go to the next screen for me, Leslie. If you guys would like to take a moment to review us on Google, we would appreciate that. If you'll go to the next screen.
Yes.
Okay, so first of all, I'd like to say thank you so much, Leslie, first and foremost, for your time this morning and educating us on this very important topic. You provided us with super helpful and extremely valuable information. So thank you. And I'd like to go ahead and talk about our next webinars with Leslie. So the next two that are coming up will be Wednesday, July 19th. Don't sign a waiver or release without reading, from 11:30 a.m. to 11:50 Eastern Standard Time. And then the next one will be on Wednesday, October 18th. And the title of that webinar will be Getting Paid Faster with Liens, Bonds, and Contracts. And that will be from 11:30 a.m. to 11:50 Eastern Standard Time. So you can go ahead and register at sunraynotice.com/education. And if you'll go to the next screen.
Yes.
And that's all we have for you guys today. We look forward to seeing you on our next webinar. Thank you so much, Leslie, for your time this morning. We really appreciate all the information you gave us today. I hope everyone has a sunny day.
Thanks, Rachel.
Thank you. Bye-bye.
Bye-bye.